Hello and welcome to yet another adrenaline shot, your short, sharp injection of something extremely valuable. And today my guest is Alicia Beverley from Como IP. Hi, Alicia.
Hi, thank you so much for having me.
It's an absolute pleasure this morning to have you on board. Now, let me tell you a little bit about Alicia. So Alicia is an award-winning presenter and entrepreneur, and she's also written extensively about intellectual property for over 20 years. She doesn't look old enough, does she, to have done that?
Thank you.
She's spoken to hundreds of top Australian and New Zealand business leaders on the topic of trademarks, copyright, patents, designs, confidential information, and IP legal agreements. Alicia's previous firm was an IP firm. It grew from 10,000 to a 1 million turnover in a regional city, which is no mean feat. And was listed in BRW's magazine's Fast 100.
Yes.
Her new firm, Como IP, provides IT protection solutions and is Australia's only developer of online IP training courses. And I'm looking forward to finding out a bit more about that, Alicia.
Thank
So I'm
you.
going to start our 5 minutes now. Whoops, I just lost my clock. Here we go. So first of all, maybe people are interested to know exactly what intellectual property or IP is.
So intellectual property is the tangible expression of creation, so that we have in some way created something and it has now a tangible form, like an app, like an email template that we're going to use many thousands of times, like a secret formula, a video. There are so many ways that intellectual property is expressed, but it must be in some form tangible, even if that tangible nature is code. So it has a digital expression, not necessarily something that we can have and hold in our hands.
Okay, so how does it actually, I guess, differ from just plain innovation? What defines the two?
Because innovation is the journey. So innovation is the activity of creating. It's the activity of change. It's the activity of attempting to, say, create new products and services or improve products and services that exist. Whereas intellectual property is the end destination. It's actually what you've arrived at. Mm-hmm. And unfortunately, because IP suffers from a bit of it's not a very sexy term, it's forgotten that that is actually the end result of innovation. We're so busy trying to innovate. So I encourage people to think of IP and innovation as either twins or two sides of the same coin. They go with each other. And business leaders need to remember that after a process of innovation, intellectual property will have resulted, and therefore actions need to be taken to protect that IP.
Yes, I guess that comes down to, why should businesses worry or be concerned about IP? What does it mean for a business?
Well, it means so much because generally, not generally, always, a business is founded on some form of intellectual property. It will go on to create IP pretty much every single day of its existence. And of course, as it evolves and becomes more sophisticated, there will be different employees, there will be contractors, all of whom are creating IP. But because the basis of IP is ultimately about ownership, and that has a direct relationship to specific laws, their actions do need to be taken. Otherwise, the default position of the law will relate to your business, and that may not be actually what you want. Just a quick example of that is, for instance, with regards to copyright. The default position in most cases is that the creator/author, which is a technical term, is the owner of the work, unless there is a legal agreement, say an assignment to the contrary. That means that anybody who's ever created copyright for you, let's say a content creator, let's say somebody who's developed designs for you, just a range of copyright such as video, ultimately is the owner of that IP unless there's an agreement to the contrary. Mm-hmm. So if you're going about creating a valuable business and perhaps intending to sell it one day, when the lawyers come in from the other side, especially if you're putting up quite a high value proposition, it's too late to sort out the assignment of that intellectual property at that time. So it's really quite crucial that we understand that we're creating IP that has value, it is protected by law, and the actions that ensure that it's owned are specific. They are specific actions to ensure you own it.
As a basic foundation, what, as a minimum, I suppose I'm saying, what should a company be thinking about going through that IP process for? So what should they be registering as intellectual property?
Well, it is important in a business to ensure that at least someone has an idea what IP is. So it's a great idea, particularly for the business leader, to really take this seriously. It's the foundation of the business, and to become passionate about it, maybe become the champion and the guru of it. So let's start with a knowledge base in the business. After that, let's determine, what do you have? You probably have a series of trademarks. That's what the business is known in the marketplace. That might be what the goods and services actually are called, so your brands. And of course, every business will have...
Told you it went fast, but keep going.
That's okay. Every business will have a slew of copyright material, all of the brochures and content and video and manuals and templates. I mean, that is just mind-boggling. But there might also be confidential information. And really, does your staff understand what is confidential? Do you have policies and procedures about the handling of confidential information? So there are several key areas, and I encourage every business to have at least one champion, preferably at the top. And it's so funny, the moment you start adding IP to your agenda, whether it's a product development agenda, a marketing agenda, executives agenda, the board meeting agenda, suddenly it becomes quite crucial to have an answer and to start looking for the IP in the business.
Yes, and I think these days, because so many businesses are going down the content creation path, you know, if you just look at what people put up online,
exactly,
there's an enormous amount of stuff. And I think we all have, I've heard people say, oh, that's in the public domain, that means that I can just use it.
Right. Well, that's not.
Do you want to comment on that?
Because just because copyright in this country and in most countries is a self-assigned right, in other words, we create the expression and therefore we have the right to say that it is our copyright. That doesn't mean that it is less valuable or somehow in the public domain. It might be publicly accessible, but that doesn't mean that it's become open to ownership by anybody who wants it. Of course, you can say that if you wish. You could dictate that the copyright is yours, but people have open ability to use it however they like. But it's best to be specific about that. And, you know, the way that we use or don't use notices, warning notices, can be really important. Most people who have registered trademarks, or most businesses, don't think to apply the registered trademark symbol, and yet that's a quite important notice. Most people who have copyright material don't apply the standard copyright notice at as a header or a footer or a watermark.
Yeah.
Similarly with confidential information, if something's confidential, you really should apply that in-house, because you certainly don't want your staff ever to be able to say, I had no idea it was confidential information. You want to be quite specific about it.
Absolutely. I think one of the biggest learnings for me was that when you use that copyright symbol, let's say as a footer,
yes,
that there's a specific format that should follow, but also it has to be the company or the company's name that is the registrant of that copyright, if you like, not your trading name or not your personal name. So it has to go. It can
be your personal name if you wish. The entity that can own copyright, it needs to be a legal entity. And the reason why it can't be a business name per se is because a business name is not a legal entity, whereas an individual is, a proprietary limited is, a publicly listed company is. So long as it has a legal status, it can be the owner of it. But the actual owner of it may, of course, be relative to a licensing agreement, as an example. And there might be terms in the licensing agreement that determine how copyright is to be portrayed. I'm just doing an intellectual property audit at the moment, and the terms of the licensing agreement are very specific about portrayal of the trademark, of the copyright, of confidential information. And, you know, in doing this audit, it was revealed that there's been no compliance with that fundamental licensing agreement. That is the basis of all of that IP.
Yeah, yeah. Wow, thank you so much, Alicia. Obviously, there's a whole lot more that we could be talking about there at some point. So one day I'd love to have you back on the show if that's okay.
It would be my pleasure. Thank you so much for having me.
It's just one of those areas that so many businesses don't spend time thinking about, in my experience, you know, through the executive connection. I've met a lot of people that are like, oh, okay, well, I've got my logo trademarked.
Yeah.
They haven't done much else, or their business name, but you know, there is so much in depth there. So thank you so much for spending time with us today.
My pleasure. Thank you so much for having me.
We look forward to seeing you again soon.
Same. Thank you.